welcome to another instalment of Defining Matters, the HSF Kramer M&A video series. My name's Jamshidi. Today I'm joined by Simon Walker. Welcome, Simon.
Thanks, Cam. Great to be here with you.
Now, you're our latest minted M&A partner.
Yes.
Public M&A specialist,
Yes.
but you can do it all.
Yes, that's right. So thanks for letting me in the club. That's very good of you. And great to be here today with you talking about Standstills.
Well, you're always welcome. A high caliber candidate like you. Anyway, enough about us. So, Standstills. Simon, the media situation, 4 bidders down to 3.
Yep.
Hotly contested standstill, I'm sure. It got us thinking, what would you be putting in if you're a bidder or a target? But first things first, at a foundational level, maybe just build up the knowledge on standstills.
Sure. A bidder will want access to non-public information of the target, but only on the condition, of course, from the target's perspective, that the bidder agrees to a standstill. And really, what do we mean when we say that? We mean it's an agreement not to acquire shares for a fixed period of time. From a target's perspective, the concern's pretty straightforward. If you're allowing another company access to your non-public information, really you're doing it on a friendly basis to do a friendly transaction. What you don't want is for the bidder to turn around later on, change the terms of the deal, potentially go hostile and use your own information against you to force a transaction that you haven't agreed to. So you can see from a target's perspective, of course, it's a pretty important setting. For the bidder, by contrast, of course, they're concerned to ensure that they've got as much flexibility as possible and they're not prevented from pursuing a transaction if circumstances change and maybe things don't pan out in the way that they thought it would. So it's a tension that arises early on in the process and, of course, 99 times out of 100 it'll get worked through, but there's a few issues you have to consider as you're doing that.
Yeah, absolutely. And so for a target, it's really, I don't want my bidder to go and buy a blocking stake or even go hostile and undermine the value lever that's available through a recommendation. That's really the crux of what the target's trying to achieve. For a bidder, they obviously want that flexibility, maximum flexibility, in particular in a competitive situation. So we'll come to that in a minute. Let's talk duration. What's market standard, do you think, Simon, in this market?
Look, it does vary. 6 usually at the bare minimum, 18 months at the outside, and sort of you can land anywhere between that. 12 is a pretty reasonable period.
And we'll talk about a situation where there was a 2-year standstill that we'll into the panel momentarily. I think that's right. That is the market standard. Now, you raise the point, market. What's interesting is the terms of these standstills are rarely made public.
That's right.
So there's no standardisation like there is in the scheme implementation deeds.
Correct.
These are under the cloak of darkness, and it makes negotiating them more challenging for participants, unless, of course, you've seen a lot of these, as we have, Simon. In addition, you see a lot of variability in the drafting of the terms, and
right.
The drafting is hypersensitive. So the most sensitive aspect, I think, Simon, is what are the exceptions? When is a bidder released from its standstill to go out there and act, and maybe just talk a little bit about that.
Yeah, well, the key one, of course, is any transaction that's ultimately recommended by the target board or agreed to by the target board is not going to be restricted. So that's really sort of point number one.
If they come through the front door, fine.
Exactly.
The target board controls it.
Makes sense. It makes sense. The next one that you often see is where a competing proposal arises and a bidder wants to be in a position to compete. They don't want to be hamstrung and it's superior to their offer. Well then, yes, often you'll see a standstill fall away in that situation. From the target's perspective though, you do actually want to make sure that that's not a totally unfettered right of the bidder at that point to put forward an offer. Sometimes you'll see that kind of restriction subject to the bidder making a competing offer that is subject only to a 50.1% minimum acceptance condition that's unwaivable. That way, you're effectively saying to the bidder, look, you can compete, but we want shareholders ultimately to decide. If you get the support of 50% of the shareholders, then you can proceed.
Yeah, that's spot on. I mean, look, acting for a bidder, I'd probably start my negotiations by saying, well, why should that only arise when there's a competing bid? I should be able to put an offer to shareholders with a 50.1% condition at any stage of the process. And I think a big reason why a target would push back on that is, again, using the recommendation as a value lever, effectively saying, well, if there's no competing proposal, you've got to come to me and we've got to negotiate and I'll only let you go if it's agreed. So that's really interesting. The US practice on standstills, we looked at this in the Newcrest Newmont situation very, very closely. I think that it's safe to say, first of all, their market is much more transparent.
It is.
The terms are often...
That's right. So you'll find that the terms of the standstills and US agreements will appear in detail in the disclosure documents that are sent to shareholders. And as a result of that, as you'd expect, there's convergence. So there's not a lot of variability between their standstills terms, and they are fairly market standard. The term, of course, is usually negotiated, as you'd expect. So some variation there, but otherwise, a relatively standard set of restrictions and exceptions.
And I think the two other features, first of all, on term, quite often longer dated terms than what we see here in Australia. So that's a tick for us in terms of facilitating M&A activity, good for the local market. Not sure why the Americans are lagging on that front. The other interesting bit is what's called a don't ask, don't give clause. I think to summarise this, and I think it's a really interesting theoretical point, if a bidder approaches the target and says, release me from my standstill, there's a director's duties question. Is that in the best interest of the company to actually release the bidder?
Yes.
Puts the target board in a difficult situation. So I think what targets were putting into these agreements were don't ask, don't give. It effectively says, don't put me in a bad situation where the board has to carefully consider its fiduciary duty as to whether to release or not.
Yeah, that's right. So in other words, the bidder's effectively pre-agreeing in that situation that they're never going to ask for the standstill to be waived, no matter what happens.
Yes, and we haven't seen that creep into the local market, but it does raise a really interesting theoretical question, I think.
It does, and I think for our particular policy settings and the presence of the Takeovers Panel, I think it would be probably quite a brave target company to ask for that, not knowing how it's going to be treated in that different regulatory setting.
I'm glad you brought the Takeovers Panel up. There's been a line of cases on standstills. We acted on the most recent one, which is the Metallica Diatreme situation. But, the core question for the panel is, what is its role when a bidder may go to the panel and say, I'm subject to a standstill, I want to make an offer, this is part of an efficient, informed and competitive market, so release me and let me actually make the offer I want to make. And why don't you go back to international all sports, where really the substance of this question first came into focus? Yeah,
so international all sports, famous panel case from back in 2009, and it sort of established, standstills as a concept, they're not objectionable in principle, and they serve a valuable purpose in protecting the confidential information of targets and enabling an efficient, competitive and informed market. So point one is that, as a concept, they're not objectionable for the panel. Point two, though, as you say, there can be circumstances in which it is unacceptable when a bidder asks to be released and a target refuses to release them. Again, that is seen to, in some cases, run contrary to the idea of having, a competitive market for control of a company if a bidder is locked up in that way. However, in the international all sport case, what they did say is that a standstill of 6 to 12 months is consistent with market practice and is commercially justifiable. So if all you're doing is asking for release on the basis that you've been locked up for 6 to 12 months, then a target's justified in refusing that request. You've got to have some other sort of special circumstances present.
And a really interesting point in that matter, Centrebet made a hostile takeover bid conditional on the standstill falling away, effectively conditional on the panel releasing Centrebet from the standstill. It's a good little point for bidders, I reckon, because often people will say, well, I'm subject to a standstill, I can't make a hostile bid. Actually, you can make a bid, it just has to be conditional on the release from the standstill.
Yes.
And what I think that can do is build a lot of pressure on a target, especially if the acceptances are rising. So I thought that was a neat little way to navigate the standstill. That also came up in our Diatreme Metallica situation as well.
So in that case, the additional question that the panel had to consider is, in the context of the standstill, what happens if confidential information is actually never disclosed? Because that is ultimately at the heart of the bargain. You're exchanging information for the restrictions. And so if no information flows, can the restrictions still stand?
What's fascinating, Simon, is if a target wanted to be difficult, they could encourage a bidder and say, look, we're going to give you access to due diligence. Give us this standstill. and then underwhelm on the information. And what they've received is they've locked the bidder down and really can tighten the screws on negotiation. We see that dynamic very early. People have cottoned onto it, and in fact, quite often a bidder will say, well, show me an index, give me a list of what you're going to give me. I need to be clear that if I'm going to give you a standstill target, I'm going to get substantive information back.
Yeah, and you sort of end up in this cascading situation where you have a bidder that says, okay, show me the index of the data room before I agree to the standstill. Okay, I've got a list of documents. How do I know that the names of these documents actually reflect the content?
Right.
Okay, do you get some sort of warranty that the content reflects the names? Even as far as saying, sometimes you'll have a bidder that wants an actual early look in the data room itself. I want a representative to go and rustle around for a few hours to make sure that what's in there is legitimately what we can expect. So practically speaking, there's a few different ways that we can deal with that, in the NDA agreement in which the standstills often contained. But I think sort of previously in the past, you might have found parties were a little bit more trusting maybe than entering into these arrangements without sort of verifying what was sitting behind them. These days, I think, a well-advised bidder wouldn't sign a standstill unless they had some kind of comfort that the information that they're expecting to see in the data room is actually there.
Yeah, absolutely. Now, I want to come back to Diatreme Metallica because I think it's a very interesting matter. Just broad brush, the facts were the parties, Metallica, the target, Diatreme, the acquirer, the parties had entered into a mutual standstill for 2 years. So I'd say outside of market practice.
Yes.
2 years. And as you say, Simon, Metallica never actually gave any information to Diatreme. And so really, Diatreme's given this standstill and got not much back in return. Some negotiations ensue, and Diatreme ultimately makes a hostile takeover bid, notwithstanding the standstill, and again, subject to that condition that it was conditional on the standstill being released, effectively the panel making orders or the parties agreeing release. So Diatreme and Metallica entered into discussions about how to navigate the standstill in light of the condition. And where they got to is effectively, if by a certain period, I think it was about a month, there was no superior proposal, they'd be released.
Yes.
If there was a superior proposal, it got a little bit murkier. Effectively, there was an exception that the standstill would be terminated if they got a shareholder approval, effectively. That creates a lot of uncertainty for Diatreme and also makes it very hard to build momentum into their takeover bid. So they went to the panel and effectively said, panel, we should be released and the conditions should be satisfied. I think they had a big chunk of acceptances. I want to say it was of the order of 40 or 50%. So, it was sort of a position of power going to the panel and a position of quite reasonable to go to the panel asking for the request. What did the panel find, Simon?
So really kind of two key findings, Cam. The first one is that it actually didn't matter that no confidential information had actually flowed. So it was found that well-advised, commercially sophisticated parties, that was fine. The fact that, the confidential information hadn't actually been provided, that didn't prevent the standstill from operating. The second point, though, and so perhaps more importantly, was that the way that the standstill had been dealt with as a result of that back and forth was that it had a really uncertain end period. So ultimately, the panel declined to make a declaration of unacceptable circumstances on Diatreme's application. But what they did do is they said, well, you've got to have an actual sort of definite endpoint for the standstill, so people know, okay, that's the point at which it will ultimately fall away.
Yeah. So basically, the panel showed the parties the writing on the wall and said, you better agree a more certain endpoint for the standstill.
Yeah. So which was 7 days after a certain specified timeline for a superior proposal to emerge.
Yeah. The takeaway for me from both international all sports and the Diatreme Metallica situation is parties should not be sitting there thinking that the panel is going to save them if they've signed up to a standstill. I think the panel is generally going to say sophisticated and well-advised parties enter into a standstill where there's a quid pro quo, the receipt of confidential information, provided the terms are sensible. The panel's going to expect the parties to hold to the standstill they've struck.
That's right.
I think that's the big takeaway.
Yeah, if you're a well-advised bidder, I don't think the panel's going to rescue you just because the panel's accepted that standstills are justifiable from both a legal and commercial perspective. However, if there are sort of uncertain aspects to them, that can be where the panel will step in and effectively bridge the gap between what the parties thought might have happened and actually how things have played out in practice. So, I think the overarching message from the panel is one of restraint. Prima facie, they're not going to be unacceptable, but you shouldn't seek to rely on the panel to rewrite the terms of them if things don't work out.
I had a question in my mind, Simon. Is that the right setting for the Takeovers Panel? And I'll go out on a limb and say, at the end of the day, Chapter 6 is designed to facilitate changes in control where the shareholders determine that it's reasonable. These standstills are a constraint or can be used as a fetter by the target in circumstances where an offer is unable to be made to shareholders. Perhaps the panel has a role to step in and effectively allow a potential change of control, or at least the offer of it to shareholders. That's one side of it.
Yes.
On the other, I can see the panel saying this is for the parties to negotiate up front with a view to how things may transpire, and they do not want to be put in a position of having to be an arbiter of whether terms are sensible and have been bargained appropriately. So I get both sides of it, but I can also see this argument that, well, this is an offer potentially beneficial to shareholders, provided the right guardrails are in place, i.e. a 50.1% acceptance condition, then maybe the panel does have a greater role.
Look, I mean, I don't disagree with you, Cam. I mean, ultimately, what I often come back to is that if you're in the position of the target, sitting there as a director, ultimately, will you facilitate an offer for the company that ultimately is not one that you're going to accept? And I think from the target's perspective, that's the key concern. You don't want to either in fact or be seen to have facilitated, a lowball offer for the company or an offer that, you as a director would not have recommended had it actually, come through the front door, as you said.
Now, Simon, there's a lot there already. We haven't even gotten into the insider trading aspects of relevant to a standstill. But I just think to myself, there is a lot there, and there's a lot of bargaining to be done early on in the engagement when a public company gets an NBIO. There's a lot to be done, and this can really slow parties down, and as you say, can be a real flashpoint, a tension point. Have we seen situations in the market where the parties have been unable to progress by virtue of a breakdown in negotiations on a standstill?
Look, there is one well-known one, and that's the engagement between Bain as the bidder and Bapcor as the target. It was reported that they were unable to reach agreement on a standstill after quite a protracted period of negotiations, and as a result of that, the transaction actually, didn't get past, first base. Yeah,
it's interesting. There's the other one was TPG InvoCare, where it was protracted, and there were multiple announcements saying we're still going on the negotiations. It's a really interesting dynamic when an NBIO has been made public and you've got to make announcements around how the standstill negotiations are going. On the one hand, there's pressure on the board, and quite often shareholders will say, aren't these market standard terms, just sign them up, let them in, we want to see an offer. On the other, you can put a pressure on the bidder. As a target, you can put pressure on the bidder and say, well, sign up to my terms and get going. And bidders are quite often keen, especially once it's in the public domain, to get going, avoid the risk of a competitive bid, for example, get deal certainty. So that tension can ebb and flow from situation to situation, but it can create a really interesting dynamic around the negotiations of the standstill itself.
Yeah, and look, following the recent panel cases for Hum Group Limited, where there was a protracted period between announcement of the NBO and signing of the NDA, I think there's going to be only more and more focus on, okay, in situations where an approach has been made public, what are the parties doing in that period between initial announcement and agreeing terms for diligence? Because in the Hum matter, the panel was quite critical of the amount of time that was taken. And previously, I don't think market participants thought that would be something that the panel identified as particularly concerning. But now I think, in those early stages of engagement, parties are going to be saying to themselves, okay, well, look, really, do we just need to kind of get on with this? And of course, as you say, when you're coming to negotiating what's ultimately quite an important commercial term in the standstill, it's just going to heighten the focus on, kind of getting to yes quickly on those provisions.
I think, Simon, the negotiations on a standstill, they sort the wheat from the chaff. Is that the right terminology?
Yes, yeah.
Because I think if you're well advised, people understand how to navigate these provisions and what the right settings are with all the commercial sensitivities in mind, and can quickly advise you on the right outcome. Whereas lawyers less experienced in these sort of deals, situations, are often a bit slower, and it just takes more time, which is generally unhelpful.
Yeah, and look, to the point you made earlier, Cam, unlike other aspects of public M&A transactions, standstill terms aren't always public. So, if you're in the position of either a target or a bidder, you're really relying on, needing to have experienced advisors who have seen it all before and are able to help you navigate through these complexities.
Well, you're the man, Simon. You've seen plenty of these and you've thought about the issues deeply. So I look forward to our next standstill negotiation. I'm glad I'm on your side, not on the other side. That's it on Standstills. If you've got any questions for us, please reach out to Simon or myself or any of our M&A partners. Simon, really enjoyed the discussion today.
Me too. Thanks, Cam.
Thanks for watching, thanks for listening, and we'll catch you on the next episode.